There you go.
You're live now.
Okay, great. Good morning, everybody. This is the meeting of the House Sexual Harassment Prevention Panel. It's February 10th, 2023, and we are here with members, Representative Maricki, Representative Brannigan, myself, Representative Burke, Representative Hedrick, and our Arlene Donovan, Human Resources person for the legislature, and Damian Leonard, our legislative counsel. Thank you all for being here.
Thank you for having us. Do you want me to just start working through the rules of procedure?
I think, yeah. So last time we had the chance to go through the policy, and now we're going through the rules of procedure. We separated these two things out last year when we redid our policy, and I think it was a really good way to do it. Okay.
Great. So we've split it up into separate rules now. It used to kind of read with numbered paragraphs. Going into the rules, section 1 is the definition section. Really the most important definitions in there are complainant, someone who has experienced or believe they've experienced sexual harassment or retaliation and has contacted the panel regarding the alleged violation. If I say potential complainant, it's someone that a witness has informed us may have experienced sexual harassment, but that individual has not contacted the panel yet or spoken to a panel member. Regulated individual is any state representative, any staff person in the House, including the House clerk. And then it does extend to legislative staff and the joint offices when they're working in the House, including in a House committee. And then respondent is an individual who's alleged to have engaged in conduct that violates the policy. So the policy starts with the informal procedure, then moves to the formal procedure. Rule 2 covers what happens when a person informally contacts the panel. Any person can do that. It does not initiate a formal complaint process. To the extent possible, the identity of the complainant or potential complainant when an informal contact is made will be kept confidential by all panel members and staff. And then when a complainant comes to a member of the panel, the first step is after the panel member has heard about the incident, explain what their options are under the policy and rules of procedure. So describe the informal process, the formal process, and talk about what the next steps might be, and ask them how they'd like to proceed. The member may approach potential, so if you're approached informally contacted by a witness, if what they've described to you could be a violation of the policy, you may at that point approach a potential complainant. You should always feel free, this isn't in the rules, but always feel free to consult with counsel or your fellow panel members. And then same thing, if a supervisor or an employee of the Office of Legislative Human Resources comes to you regarding a potential incident, again, you may approach the complainant at that point to determine if they'd like to proceed with either an informal resolution or a formal process. In every instance that you're approached, you're required to inform the other panel members that an incident occurred. The policy says of the incident or conduct. One of the things that is up for discussion is whether it makes sense to disclose the details of the incident or conduct, or whether it just makes sense to say we've been informed that an incident occurred between these two individuals, or just that an incident occurred and myself and this panel member are working to resolve it. So that
revealing the names of the complainant, correct?
Right. We do keep a record, so a panel member can always access that. the question is, how much information do you want to be circulating at the time of the informal complaint? So any panel member is allowed to come to my office at any time and access any records of the panel, to look back, to determine if there's a pattern, to provide context to a complaint if someone says, well, I came before and nothing happened. So there's all, that information's always available, but the question really is, when we say inform the other panel members of the incident or conduct, the question that came up late last session was, well, what does that mean? And we didn't address it in the rules. It came up after we'd finalized the rules. So just highlighting as a point of discussion for later, not something we need to decide today. The next thing you're required to inform whoever contacts you is that the panel may need to gather additional information. And then that the panel is obligated to take immediate and appropriate action to ensure that conduct that violates the policy stops. That action does not have to be like a formal process or a formal hearing. It can involve anything from developing a safety plan with the individual who may have been harassed, to having an informal conversation with the alleged harasser, to strategizing with a supervisor to prevent the conduct from occurring again, working with a committee chair. It runs the gamut, but we are obligated under the law to take action to prevent it from becoming a pervasive situation where the conduct continues and happens over and over again. And then you are required under subsection D to consult with legislative human resources and either alleged counsel or outside counsel as appropriate under the circumstances. As I mentioned at our last meeting, we do have outside counsel on retainer now, and Arlene could facilitate a contact with them if there's an incident, particularly if the way this process would work is typically you would contact Arlene. You could contact me. There are two reasons why either myself or another member from Ledge Council would say we shouldn't be involved. The first is workload. If it's the last week of the session, we may not have the bandwidth to properly staff the panel. Or even if we're just in the process of getting a really big bill through one of the chambers, our bandwidth may be diminished to the point where we can't provide you with good legal service. The other is if we're conflicted. It's a very small building in a small community, and the likelihood of a potential conflict of interest, or at least the perception that we're too closely aligned with one party, is very high. So in that instance, we would defer and go to outside counsel so that there's an individual who's not in the building who could conduct the investigation or provide legal advice to the panel, whatever's necessary. Any questions?
No. Anybody? I have a question. So we do have somebody on retainer, correct?
We do. Lynn, Blackman and Minitsky,
Yeah.
the firm in Burlington. Pietro Lynn, one of the partners of the firm, is our primary contact, but then depending on the nature of the issue, he may delegate that to someone else in the firm who has better expertise. Or if for some reason he's unavailable because of a trial or something like that, he would also delegate. So, okay. So the next step is the actual resolution of the informal complaint. So I talked about that a little bit. This is at the complainant's request, assuming that there's not a reason that the panel has to take action to prevent some sort of ongoing behavior. Panel is permitted to gather information as necessary and is required to consult with legislative human resources and either legislative counsel or outside counsel as appropriate. And then 2 or more panel members have to meet with the alleged harasser or the regulated individual who allegedly engaged in the harassment. We do this for a couple of reasons. The biggest one is so that we have 2 people from the panel who recall what happened. Ideally, following that conversation, you don't necessarily have to take notes in the conversation, but immediately afterwards, you'll record your recollection of what was said, what was agreed to. And informal resolutions, they can sometimes be a mediated discussion where panel members would mediate a discussion between the 2 parties, ideally reaching an apology or an acknowledgement that what they did was hurtful. But in any event, whatever happens, we need to keep a brief but contemporaneous record of what was said and agreed to. So that if we have to go back in the future, it's not just, didn't we talk to them 2 years ago about a similar incident? We've actually got a record.
So those notes, are they kept by Ledge Council?
At the moment,
HR?
At the moment, they are being kept in a locked drawer in my office.
Okay.
I am hoping to set up a way for the IT department to give us a secure SharePoint site where it'll only be accessible to HR, myself, Jen Carvey, and then members of the panel to access the documents. And then you could basically just send a document to that site if you didn't want to write it out physically. If you want to write it out physically, you can provide it to me and I keep these in a file in my office.
So are all notes currently in paper format? They're not saved electronically?
Some of them are electronic, some of them are paper.
And have you scanned the paper?
I have not.
Okay.
So
I don't know how deep that stack is.
it's not very deep.
Okay.
So, and this is relatively recent.
Yeah.
So
Okay.
the filing, to be completely honest, the filing is being done in my office, but it's in the process of being improved because for the longest time, we had very few
Sure.
documents. And so at this point, I'm moving things around and dedicating
Do you have any
space,
sort
but
of
yeah.
database that, or program that tracks, like, does HR have any sort of, so let me give you full context here is I work in my other job at the Center for Student Conduct at UVM, and we are adjacent to the Title IX sexual misconduct investigations, and we facilitate those processes. So we're the ones taking these notes. And but we have a whole, so it would surprise me that HR doesn't have an ability to secure these sorts of files for, employees or legislators who have gone through this process.
Electronically.
Yeah.
We certainly have the, like a locked, area in HR for the hard copies. And for the electronic files, we really don't have a secure database,
Okay.
for them.
Not at the moment.
Yeah.
So there are a couple of things going on, and it really comes down to just limited resources and getting this moved along. But the panels are relatively new.
Sure.
HR is very new.
Very new.
We've never even had an HR person. You see,
Brand new.
Yeah. So
Where are other sensitive documents for employees?
those are kept with HR.
Okay.
So
Electronically?
yeah, traditionally,
They're locked up. So if they're electronic, I would typically print them out and put them in a locked cabinet so that they are all together and they're not,
Okay.
in 2 different or 3 different places.
Okay.
yeah, historically, HR functions until, how long have you been with us, Arlene? Just short of 2 years?
Yep, just short of 2 years.
So, and that's as long as we've had an HR department here.
Okay.
So
But we're
this
getting
is,
there.
yeah. So
trust
it was a multi-year effort to first get an HR department. We're still working to get them enough staff
Okay.
to catch up because we haven't had unified policies. But now we finally have centralized documents. We have centralized HR services. Ledge Council has traditionally staffed the discrimination and sexual harassment panels, and also staffed sensitive employment issues. So we are shifting away from that for a variety of reasons. The biggest one being the conflict issue that I described earlier. So we're still in process. I've been talking to IT about getting a secure site set up, but because of other things, we haven't gotten to the top of that list yet for projects. But that would be the next thing, is to set up a secure site where we can track complaints, where we can do a name search and realize, like, okay, we've got three past complaints. Because the other thing is, the membership of this panel turns over slightly every biennium. And so, new members may not realize that the person that they were just informally contacted about has had prior contacts. And we're fortunate not to have had too many repeat cases at this point, but the likelihood is that, like any other workplace, we will have people who need repeated reminders at the minimum to,
I also want to add that this is not the only thing that you're being asked to do in terms of,
Yes.
I mean, Ledge Council is, so
A little busy.
so many responsibilities and intensive things especially when certain bills are moving. So I just want to acknowledge that we appreciate your.
It's the challenges of being in a small state with a small citizen-led legislature. We have very limited staff resources and limited funding. So we're working to bring this up, and the General Assembly was good enough to move in the direction of bringing in professionalized HR staffing in the last couple of years, because that's just been a major challenge. And I think it's made a huge difference here. So, we're really lucky to have Arlene on board and to have Eliza with us to help us out with these things, because it was stuff that we did when we finished the rest of our work for the day. And so you can imagine we were stretched extremely thin and probably weren't doing the best job.
Sure.
So.
But the good news is that this is one of our priorities. So we have a whole list of priorities, and this is definitely on the radar. So we're sort of building the department as we're managing the department and doing the day-to-day, but it's not lost on us for sure.
Yeah.
It's important.
But I would say your experience would be invaluable in helping us to develop
Incredibly impressed so far.
the next steps. So,
Lock tight.
right. So, back to informal complaint resolutions. We will not get through this today, but so brief record. Records kept confidential and cannot be disclosed to anyone except a current panel member or staff person for the panel. Chair of the panel promptly informs the speaker that there was a resolution, but not of the incident or conduct or the identities of any individual who's involved. Preventative action, as I mentioned before, we have a legal obligation to ensure that this is a safe workplace without sexual harassment occurring. So if an individual contacts you informally and then decides not to pursue action, you do need to promptly inform other panel members and consult with human resources and either Ledge Council or outside counsel about whether further action needs to be taken. I would strongly advise against making that decision on your own. Not that I don't trust any of your judgments, but sometimes it's good to have the perspective of the other voices in the room saying, hold on here. Particularly staff where we may have heard of similar things occurring elsewhere, but that have been brought to other panels. We can't disclose the the details to you, but we can certainly say, no, this is an issue that we need to stop now because this is the second time in a week that we've heard of similar conduct. And so that's enough of a pattern that we need to step in, even if the conduct may be minor in the particular incident and doesn't appear likely to repeat on the surface. So
in that case, then the panel would meet and make a committee decision?
So the way we've done it in the past is to inform all the other panel members of the incident. If it warrants a full discussion, we can call a meeting. We'll have a confidential, non-public meeting to discuss. The other option is for the panel member who received the informal complaint and one or two other panel members who are available to meet with staff for the panel to discuss how to move forward. And that this is a recognition that particularly at crossover and the end of the session, it can be hard to get all 5 panel members together in a room for more than a minute.
Yeah.
And so that, but the important thing is that we have at least panel members know what's happening and that we have a couple of panel members meeting with staff to discuss so that there's variety of perspectives. And then the panel members who meet with staff, typically 2 of those panel members will become, if there's a need for some sort of informal action, they will take that action. So that often what happens is it just gets delegated at that point to who's got the time available or is not conflicted. Because that's the other thing. If it's your seatmate or someone you sit next to in committee, you may not be comfortable doing an informal resolution with them.
It can also be like whoever contacts you,
Right.
the member of the panel who's contacted would be the,
Right. They're the first person.
yeah.
And unless they have an apparent conflict, it'll be them and 1 or 2 other panel members.
Do we have to meet in person?
No, we can meet remotely. Under House rules to take official panel action, we have to meet in person when we're in the building. And then I think we will need to get authorization by resolution for the summit to meet remotely as necessary.
Didn't we get that?
I don't know if is it a permanent rule? Did we get a permanent rule?
Sure, but we did
should check.
something, yeah.
Because I know we got a resolution at the end of last session.
Yeah.
Sorry, Molly.
Oh.
I have to go.
Thank you,
I
okay.
told her I would be back.
Yeah,
for the
totally,
meeting.
yeah.
Sorry. So do I see you next week, same
Well, I
place?
think that's,
I
can
have it on my-
everybody meet next?
I have it on my calendar already.
Yeah, okay.
Okay.
I think that would be good,
Great.
yeah? Is it okay with
Sorry to
everybody?
leave.
Oh, no, that's fine. We understand.
And
Here.
a shift has just happened now that we don't have a Republican here.
Oh, you're right.
Yeah. It probably makes sense to,
Oh, Patty's not here today.
Right.
Right.
so, yeah, we can stop for now and keep going later. I can answer questions if you have them.
Is there any sort of mandated reporter status?
The mandatory reporter applies. We are not mandated reporters, but our policy requires that if the individual is or appears to be under 18,
Yep.
we have to report.
Okay.
But other than that, we're not mandatory reporters. Some members may have that status from their outside profession. So, but that as a panel and as members of the legislature.
Can you talk about how that would come in?
How it would come to here?
Yeah.
Or, I mean, my understanding is if someone under 18 shares something that we have to.
Yeah, that. Oh, I thought you rose your hand when,
No.
if we're mandatory reporters outside of our role.
No.
Yeah.
I mean, mine is on campus, but
Yeah.
that's,
Yeah.
not going to intersect here, I don't think. Well, I guess an intern. but-
It could with the interns in the building. Yeah, so there may be overlap for some members in the building, but the biggest thing is particularly with the pages and then student groups coming through the building. If we see or hear or become aware of anything, that's a mandatory report to the Sergeant at Arms and Capitol Police. Within the policy though, there's no provision for mandatory reporting. There is the legal obligation that's on anyone in a position of authority in a supervisory role to take action. So
Was that talked about, bringing mandatory reporting, like for every member of the legislation?
it was, we've talked about it at different times, looking at past versions of the policy. It has not been adopted, in part because of concerns about who would be responsible for reporting, who would receive the reports, and concerns about the extent to which people understood what that involved. So, but yeah, it's something that could be talked about again in the future, but at this point, the decision's been not to require mandatory reporting.
Can I ask a second question that's unrelated or a new topic?
Pardon me?
We good for a new topic? I have a second question, but it's.
Oh, yeah. Oh, sure.
I want
Yeah,
to make sure
yeah,
we're
yeah.
closed out here.
Of course.
At some point, we don't have to do that now, and I think it would be helpful as, I'll be curious on your perspective on the difference between, or the threshold between preponderance of the evidence and clear and convincing, because clear and convincing is in your policy, and I'm
Yes.
much more accustomed to preponderance.
Yes, that has been an issue of discussion in the past, is an understatement. So clear and convincing is the standard that the legislature has adopted. It is a higher standard than we would see elsewhere. So preponderance is, as you know, it's anything over 50%. Clear and convincing means, and I always forget the exact descriptors, but it has to be,
Clear and convincing.
yeah, I mean, it has to be a reliable, concrete evidence that basically makes a substantially convincing case that the conduct occurred. It's not beyond a shadow of a doubt. But it is a higher standard. We have discussed the possibility of lowering the standard in the past, but that hasn't happened.
What
And
would it take to do that?
just a policy change. So the policy provides for clear and convincing. We could change it to preponderance. I think one of the concerns about clear and convincing versus preponderance is that these are citizen panels. And that, I'm not saying it's the right concern or the wrong concern, but that's been one of the concerns in the past. The concern on the other side is that even though our policy has a lower standard than the law in terms of, or a lower threshold than the law for a violation, by setting up a clear and convincing standard, the formal process may make it so that if the evidence is shaky, you don't have a finding that the sexual harassment occurred, where you would get a finding that it occurred under a preponderance standard. And if it's severe pervasive behavior, you could have an instance where it goes to the Human Rights Commission.
Consider this. I know we probably have to bring leadership in to that
Yeah, it's also,
sense.
Yeah, it's an interesting question. I wasn't part of these other prior conversations. I can see where it would be a topic of discussion.
Right.
Because,
When's the last time it was discussed?
it gets discussed every time we update the rules of procedure. I think last year we did not spend a great deal of time on it. The prior update, though, we spent a fair amount of time talking about it. And certainly when we first got a unified policy with the Senate, there was a lot of discussion about it at that point. One of the things that now that you have a separate rules of procedure and policy, is if you go to unified policy with the Senate, but you keep separate rules of procedure, the House is free to change its standard of proof without hoping that the Senate follows suit and then having to negotiate that. So, and that, I think that's been one of the challenges in the past, is just trying to get unified procedures, because the House and the Senate do things differently and they function differently. And so that's caused a lot of challenges in the past, where the House has typically been the first to propose a change to the policy, and then the Senate typically counter proposes with a different or lesser change. And I'm not saying that one approach is better or not, but the pattern in the past has been the House updates their policy, and then the Senate follows later, and then the House changes its policy to coincide with what the Senate is able to get through their committee. But now that we've separated out rules of procedure, you don't have to wait for them on something like this. You could do it, and it's just how your internal procedures run, and they can have a different internal procedure. So, which may make it a good time to discuss things like that again. So,
But when we have our full complement,
Yeah.
like to
Okay.
see it put on our discussion list.
Yeah, I agree.
Yeah, so I think next time we can go through the informal or the formal process, and we'll be able to finish. I can go through that quicker.
And then we can talk about the facilitators.
And then we can talk about facilitators, yes. So,
And maybe give a little history.
yeah, and we can talk about whether it's appropriate to do that at this point,
Yeah.
whether it makes sense.
Yeah.
So,
Great.
yeah.
All right. Thank you, everybody.
Thank you. All right. Well, I'll see you guys
Extra
shortly
time.
for discrimination training.